My Lords, I think this has been one of the most important debates that we've had so far in this committee, covering most of the issues in Clause 12 of the bill, effectively the replacement of the legal but harmful provisions that were in the draft bill, and with the user empowerment tools introducing the new element of the triple shield, or the three-legged stool, as we're now going to describe it, thanks to Baroness Fraser. It's about how we as adults are empowered to protect ourselves from harmful content and, most crucially, the amplification of the harm caused by the systems used on the platforms. And I want to start by welcoming the subsections in the text of Clause 12 in 4 and 5 about ease of use and ease of access of the tools. Many platforms already offer these sorts of tools, and the Noble Lord Clement Jones referred to the parent zone research that's been circulated, and they talked about a Facebook tool to prevent the autoplay of ads, and it took their tech-savvy researcher, not Baroness Burt, but a tech-savvy researcher, 3.5 hours to work out how to turn off the autoplay of ads. And they also found that 30% of tools have changed in the last year. So this is an ever-moving target for people to chase after. And the reality, of course, is that most of us don't have the time, even if we have the inclination, to deal with all of these things. We already have user empowerment tools around unsubscribing from junk emails, and how many of us can be bothered to go through all of that all the time? Sometimes do, sometimes I just have to delete them and move on. We have to manage cookies, and sometimes I do, and sometimes I don't go in and manage my cookies because I don't have time. And that's why, in the end, we need to be looking seriously at putting some of these tools on by default with easily accessible settings to then turn them off if desired. And so I support the amendments 34 and 35 tabled by Baroness Moylan, although I kind of support Lord Clement Jones's ones more, which is why I put my name to them before this debate started. But what she talked about in respect of self-harm, suicide and eating disorders is really important. And again, in my mind, this is less about them never being able to see individual items of content relating to those things, and much more about restraining the platforms from bombarding us with similar content, as happened to Molly Russell and others. And here, of course, as many noble lords have said, we should be mindful of the vulnerability of many young adults and other adults to the same experience that was implicated in Molly's death. And according to Refuge's research that was circulated, 1 in 3 UK women, just over, have experienced online abuse or harassment on social media, and perpetrators of domestic abuse are increasingly turning to technology as a tool to further their abuse. A briefing sent by the Royal College of Psychiatrists says that, according to NHS England, only 57.5% of 17 to 24-year-olds feel safe using social media in this country. So why not improve their safety as adults by having them opt in to seeing potentially harmful content? This is particularly important to some vulnerable adults with limited capacity to make decisions about internet and social media use without limiting the freedom of adults to see this content if they want to. And Lord Clement Jones, in Amendment 36 and 37, which I add in my name to, I think is essentially going back to some of the debate about safety by design. The platforms are designed, as the Right Reverend Prelate set out so powerfully, designed to maximise engagement, to maximise time on site, to maximise data collection, to maximise the targeting of advertising. It's about their business model, it's not about our safety. The artificial intelligence has not an ethical constraint, and these user empowerment tools allow us to shift the algorithm in our favour, including to make us safer. To toggle them off is to side with the business model, regardless of adult safety. To toggle them on is to side with adults having a more pleasant but slightly less engaging experience. Whose side is the Minister on. We look forward to hearing.
Just a clarification. We've reduced, in a way, this debate to whether the default position on or off. Although, in fact, I actually think that's only one aspect of this. My concern, and what I actually maybe spent too long talking about, but was what happens if you turn them on? Because the assumption we keep making is once they're on, we're safe. But the difficulty, or the question I have is, the kind of categorization of what's filtered out under turning them on isn't necessarily that which the user thinks they are doing. So I'm simply asking, how do you get around that? Because it seems to me, otherwise we think it's too easy, turn it on or off. Yeah, and press the button too. But if you think you're going to stop seeing hate, and then hate is actually legitimate, political, interesting ideas, isn't that problematic for you all?
As ever, the Noble Baroness is an important voice in sort of bursting our bubble in the chamber, and I continue to respect her for that. I think, in response to her, that it's not going to be perfect. There isn't a perfect answer to all of this. I am siding on the side of safety and caution rather than a bit of a free-for-all. Sometimes there may be over-caution, and sometimes there may be aspects of debate where the platforms, the regulator, media, discussion, debate in this chamber would say, yeah, the toggles have got it wrong. But we just have to make a judgment about which side we're on, and that's what I'm looking forward to hearing from the Minister. And these amendments are supported on all sides by a long list of organisations, as listed by Baroness Morgan and by the Noble Lord Clement Jones. And the Minister's not conceding very much at all so far to this committee. And we've heard compelling speeches, such as those from Baroness Parliamentary, reinforcing my sense that this one is something that he needs to give in on when we come to report. I also want to speak to Amendment 38A in my name and pay tribute to John Penrose, the aforementioned, and his work, as you know, the Member of Parliament who mentioned by the Noble Baroness, and his work in raising concerns about misinformation and stimulating discussion outside of the chambers, but amongst parliamentarians and others. And following discussions with him and others in the other place, I propose that users of social media should have the option to filter out content whose provenance cannot be authenticated. As we know, social media platforms are often awash with content that is unverified, misleading, or downright false. This can be particularly problematic when it comes to sensitive or controversial topics such as elections, health, or public safety. In these instances, it can be difficult for users to know whether the information presented to them is accurate or not. Many of your lordships will be familiar with the deep fake photograph of the Pope in a white puffer jacket that recently went viral, or the use of imagery for propaganda purposes following the Russian invasion of Ukraine. And the Content Authenticity Initiative have created an open industry standard for content authenticity and provenance. And right now, tools like Adobe Photoshop are allowing users to turn on content credentials to securely attach the provenance data to images and any edits then made to those images. And that technology has now been adopted by camera manufacturers like Leica and Nikon. So the technology is there to do some of this, to help give us some reassurance. So this proposal in Amendment 38A allows users to filter out unverified content and is designed to flag posts or articles that do not come from a reliable source or have not been independently verified by a reputable third party. Users could then choose to ignore or filter out such content, ensuring that they are only exposed to information that has been vetted and verified. And I would suggest, my lords, that this would not only help users to make more informed decisions, but would also help to combat the spread of false information on social media platforms. And by giving users the power to filter out unverified content, we can help to ensure that social media platforms are not used to spread harmful disinformation or misinformation. I'd also like to speak to Amendments 42 and 45 in the name of my noble friend Lord Stevenson. These are good, straightforward improvements to the bill in suggesting that subsection 11 of section 12 should simply include all protected characteristics in the Equality Act of 2010. And I listened closely to Baroness Buscombe and her argument about listing the various characteristics, and I think it makes much more sense to do what my noble friend is suggesting and just reference the Equality Act, and then if we choose separately to amend the Equality Act to change protected characteristics, then that change would flow through into this bill and would seem a much more sensible and pragmatic way to proceed. And similarly, Amendment 45, my noble friends are suggesting that consideration should be made by the Secretary of State as to whether any of these tools should also be available to child users, and we've heard good arguments in favour of that in terms of dealing with the cliff edge effect as described by Baroness Kidron. Finally, perhaps you'll forgive me slightly bizarrely, Amendment 283ZA in the name of Baroness Fox invites us to consider, in following on from section 7 in part 11 of section 170, invites us to consider, amongst other things, whether a bot can act reasonably. Given self-coding bots are now technically possible, I'll be fascinated to hear the Minister's view on whether an autonomous bot can have reason. Now, I did ask ChatGPT this question, and for the help of the House, it replied, "As an artificial intelligence language model, I do not have consciousness or emotions, and therefore I do not have a capacity for reason in the way that humans understand it. However, I am programmed to use advanced algorithms that allow me to process and analyze large amounts of data, recognize patterns, and provide reasoned responses based on the information available to me. This allows me to simulate a form of reasoning, but it is important to note that it's not the same as human reasoning, as I do not have subjective experience or personal biases. Ultimately, my abilities are limited to the algorithms and data that have been programmed into my system, and I cannot generate my own subjective experiences or judgments." So that's the view of the algorithm as to whether or not bots can have reason, and I look forward to the Minister's response.
My Lords, the Government recognises the objectives behind the amendments in this group to strengthen protections for adults online, and I hope noble Lords will agree that the bill will indeed significantly improve the safety of all adult users, particularly those who are more vulnerable. The user empowerment content features will not be the only measures in the bill which protect adults. They will act as the final layer of protection, coming after the duties on illegal content and the requirement on Category 1 providers to uphold their terms of service. But as the Clause 12 duties apply to legal content, we need to tread very carefully and not inadvertently restrict free expression. Amendments 34 and 35 in the name of my noble friend Lady Morgan of Cotes, and Amendments 36 and 37 in the name of the noble Lord Clement Jones seek to require Category 1 services to have their user empowerment content features in operation as a default for adult users. The Government shares concerns about users who experience disproportionate levels of abuse online, or those who are more susceptible to suicide, self-harm or eating disorder content. But these amendments encroach on users' rights in two ways. First, these amendments intend to make the decision about whether to have these features turned on behalf of users. That it is especially aimed at those who might not otherwise choose to use those features. The Government does not consider it appropriate to take this choice away from adults, who must be allowed to decide for themselves what legal content they see online. We saw the debate really was distilled in the exchange between the noble Lord Knight and the noble Baroness Lady Fox in their interaction just now, with the noble Lord said he would err on the side of caution, even if over caution. He characterised the other side as a free-for-all. I might say it was erring on the side of freedom. But this is the debate that we are having and should have when looking at these parts of the bill. Second, these amendments would amount to a government requirement to limit adults' access to legal content. This presents real freedom of expression concerns, which the government cannot accept. Third, I would remind Noble Lords that there are a range of measures which providers can put in place.
May I ask the Noble Lord the Minister, do you think that the government therefore is condoning the current system where we're inundated with material algorithmically that we don't want? Is that the government condoning that behaviour in the way that you're saying that if you would be condoning a safety measure?
We come to talk about algorithms and their risks later on, but say it is an important balance to strike here, and one that we have rightly debated in this group. But I would remind Noble Lords there are a range of measures that providers.
Just because of the importance of that point in relation to what you're about to say, can we just be quite clear about this? The decision that you are ruling out the ability to prioritise the needs and requirements of those who are unable to take the decisions effectively themselves in favour of a broader consideration of freedom of expression. I think it's really helpful for the future of this debate just to be clear on that particular point.
We'll come to say in a moment the provisions that are in the bill to make sure that the decisions can be taken by adults, including vulnerable adults, easily and clearly. So if the Noble Lord will allow, I'll cover that point. I was in the middle of reminding Noble Lords that there are a range of measures that providers can put in place under the duties, some of which might have an impact on a user's experience if they were required to be switched on by default. That might include, for instance, restricting a user's newsfeed only to content from connected users, adding to the echo chamber and silos of social media, which I know many Noble Lords would join me in decrying. And we think it is right that this decision is for individual users to make. The bill sets out that the user empowerment content tools must be offered to all adult users, and that it must be easy to access, to the point raised just now, but also raised by my noble friend Lady Harding, the noble Baroness Lady Burt, and as Noble Lords are right to remind us, pushed by the noble Baroness Lady Campbell of Surbiton, who I'm pleased to say I've been able to have discussions with separately from this committee. Providers will also be required to have clear and accessible terms of service about what tools are offered on their service and how users might take advantage of them. Ofcom will be able to require Category 1 services to report on the user empowerment tools in use through transparency reports, and Ofcom is also bound by the Communications Act 2003 and the Public Sector Equality Duty, so will need to take into account the ways in which people with certain characteristics, including people with disabilities, may be affected when performing its duties, such as writing the codes of practice for the user empowerment duties. A number of Noble Lords in their contributions referred to the
I'm grateful to the Minister, and I think he is trying to answer the point about vulnerable adults that in what he's saying, that raised by my noble friend. And I'm just interested in the extent to which he's relying on the Equality Act duty on Ofcom to then impact the behaviour of the platforms that it's regulating in respect of how they're protecting vulnerable adults. So, because my understanding is the Equality Act duty will not apply to the platforms, just Ofcom in the way that it regulates the platforms, and I'm just unclear how that is going to provide the protection that we want.
Yes, that is right. The platforms are not public sector, so the public sector equality duty doesn't apply to them, but it does apply to Ofcom for taking into account the ways in which people with certain characteristics can be affected through the codes of practice and the user empowerment duties that it is enforcing. So it suffuses the thinking there, but the duty is on Ofcom as a public sector body. We talk later in 1211 of some of the characteristics which are similar to the protected characteristics of the Equality Act 2010 in clause 1211. And I'll come to that again shortly to follow the points that both noble lords made. I wanted to say a bit about the idea of there being a cliff edge at the age of 18 that was raised by a number of noble lords, the noble Lord Griffiths, my noble friends Lady Morgan and Lady Harding, and the noble Baroness Lady Kidron. The bill's protections recognise that in law people become adults when they turn 18, but it's not right to say that there are no protections for young adults. The bill will provide, as noble lords know, a triple shield of protection, of which the user empowerment duties are the final element. The bill will already protect young adults from illegal content and content which is prohibited in terms and conditions. As we discussed in the last group, platforms have strong commercial incentives to prohibit content that the majority of their users do not want to see, and our terms of service duties will make sure that they are transparent and that they're accountable for how they treat this type of content.
Adults from older adults in what the Minister is saying?
In law, nothing. I'm engaging with the point that was made that there is no, there's not a cliff edge here. There are protections for people once they turn 18. People's tastes, their risk appetites may change with time, but there are protections in the bill for people of all ages.
That Baroness Kidron was making, surely, is that as soon as you reach 18, there's no graduation at all. There's no accounting for vulnerable adults.
It is not this cliff edge which noble lords have feared, that there are protections for children and then the 18 are free for all. There are protections for adult users, young adults, older adults, adults of any age, through the means I've just set out, through the triple shield and the illegal content provisions. Perhaps may have confused the noble lord in my attempt to address the point, but the protections are there.
Circularity to what the Minister is saying in all of this. Because it's precisely that's why the default option is the one that we're arguing for, that it allows that vulnerability to be taken account of.
If the Minister wanted to just set out for us the difference, because clearly this committee has spent some time debating the protection for children, and that the protection for children is a higher bar than the protection for adults. And so it's not possible to argue that there's not going to be a difference on the age of 18, however effective the first two elements of the triple shield are. And maybe he needs to think about it by coming at it from the point of view of being a child, becoming an adult, and just talk us through what that difference will be.
Once at the age of 18, somebody becomes in law an adult. They are protected through the triple shield in the bill, the user empowerment duties being one element of that, but also from the illegal content duties and the protection against content prohibited in terms and conditions, and the redress through Ofcom. The legislation delivers protections for adults in a way that preserves their choice. That is important. At the age of 18, you can choose to go into a bookshop. You can choose to encounter this content online if you want. It's not for the right for the government to make decisions on behalf of adults about the legal content that they see. The bill doesn't set a definition of vulnerable adults because it would risk treating particular adults differently within the bill or unfairly restricting their access to legal content or their ability to express themselves. There's no established basis on which to do that in relation to vulnerability. And finally, we remain committed to introducing a new criminal offence to capture communications which intentionally encourage or assist serious self-harm, including eating disorders, which will provide another layer of protection on top of the regulatory framework for both adults and children.
And I understand all of that, I think, but that's not the regime being applied to children. And it's really clear that children have a safer, better experience. And it's the difference between those experiences suddenly happening on an 18th birthday that we're concerned about.
And before the Minister stands up, a new phrase, can he say, can he just confirm that it's perfectly valid to have a choice to lift a user empowerment tool just as it is to impose it? So it's still, choice would still be there if our amendments were accepted, my lords.
It would be, but we fear the chilling effect that that having the choice imposed on people to as the noble Baroness Lady Fox rightly put it, one doesn't know what one hasn't encountered, and until one has engaged with the idea at the age of 18, people are given the choice to decide what they encounter online. They're given the tools to ensure that they do not encounter it if they do not wish to do so. And the noble lord has heard me say many times the strongest protections in the bill are for children. The bill, we've been very clear, the bill does have extra protections for people under the age of 18. For adult users, young and old adults, it preserves their choice and the freedom of expression online. My noble friend Lady Buscombe asked about the list at clause 12 subsection 11. We will keep that under constant review and may consider updating it should compelling evidence emerge, but as that list covers content which is legal and which is designed for adults, it's right that it should be updated by primary legislation after a period of parliamentary scrutiny. Amendments 42 and 38A, tabled by the noble lords Lord Stevenson of Balmacara and Lord Knight of Weymouth, respectively, seek to change the scope of user empowerment content features. Amendment 38A seeks to expand the user empowerment content features to include the restriction of content, the provenance of which cannot be authenticated. Amendment 42 would apply the features to content which is abusive on the basis of characteristics protected under the Equality Act 2010. The user empowerment content list reflects areas where there is the greatest need for users to be offered choice about reducing their exposure to types of content. While I'm sympathetic to the intention behind these amendments, they do, I fear, risk unintended consequences for users' rights online. The government's approach recognises the importance of having clear, enforceable and technically feasible duties which don't infringe users' rights to free expression, and these amendments risk undermining this. For instance, Amendment 38A would require the authentication of the provenance of every piece of content present on a service. That could have severe implications for freedom of expression given its all-encompassing scope. Companies may choose not to have something at all.
To help the Minister, what the amendment seeks to do, and if it's been poorly drafted I apologise, is not to require a platform to check the provenance of every piece of content, but for those that are certified as having good provenance, they would have the priority for me to be able to see. In the same way as in the bill, verified users can be something that I can see or not see. Verified content could be things I could choose to see or not see.
Thank you. When I may be reading his Amendment 38A excessively critically, I will look at it again. But to try and reassure the noble lord, the bill does already ensure that all services take steps to remove illegal, manufactured or manipulated content when they become aware of it, so the harmful the most harmful and illegal misinformation, disinformation is of course covered that way. In relation to Amendment 42, this would require providers to try to establish on a large scale what is a genuinely held belief and more than an opinion. In response, providers would, I fear, excessively apply the user empowerment features to manage that burden. The Noble Lord asked, and a number of Noble Lords referred to the discrepancy between the listed.
My papers and I got confused. I'm very grateful to the Noble Lord for giving me. Several times in the bill, but this is a very clear example. The drafters have chosen to impose a different sequence and words to that which already exists in statute. And the obvious one here is the Equalities Act, which we've touched on before, and Baroness Buscombe made a number of points about it which aren't very serious. Why is it that the government has chosen to list separately and distinctively the characteristics for which we have also heard through a different route the regulator will be required to uphold the statute, but the companies will be looking to the text of the bill or the act as it becomes? Isn't that just going to cause chaos?
It comes to the point we touched on earlier, that the Ofcom as a public body is subject to the public sector equality duty, and therefore the list set out in the Equality Act 2010. The list at clause 12 subsection 11 is relates to content which is abusive, and therefore for providers to look at. And while the Equality Act has established an understanding of characteristics which should be given special protection in law, it's not necessarily desirable to transpose those across. I mean, they too are susceptible to the point made by my noble friend Lady Buscombe about lists that are set out in statute. I think, actually, if I remember rightly, the Equality Act was part of a wash-up at the end of that Parliament, and whether Parliament debated it as thoroughly as it's debating this bill is a moot point. But
and to pick him up on that, I really don't think it's right to classify our legislation as to whether or not it came through in a short period or in a long period. We're taking an awful long time about this. It's not going to make it any better. I was involved in the Equalities Act, and I've scars my back to prove it. And I think it's a jolly good piece of legislation and stood the test of time. I just don't think you're right, that the point is being answered properly by that, by simply saying that this is a better way of doing it. You said 1211 was about abuse targets. 1212 is about hatred against people. And 1213 is a series of explanatory points. These are all grist to the lawyers, my lords. They're not trying to clarify the way in which we operate this, in my view, to the best benefit of those who are affected by it.
Content which we've added to clause 12 is a targeted approach. It reflects input from a wide range of interested parties with whom we have spoken about it in the areas of content that users are most concerned about. The other protected characteristics that don't appear are, for instance, somebody's marriage or civil partnership status, or whether they are pregnant or not. We focused on the areas where there is a greatest need for users to be offered the choice about reducing their exposure to types of content because of the abuse that they may get from it. And it recognises the importance of clear, enforceable and technically feasible duties. As I said a moment ago in relation to the point made by my noble friend Lady Buscombe, we will keep it under review, but it's right that these are debated at length, and greater length than I think the Equality Act was, but this was long before my time in your Lordship's house, so I defer to the noble Lord on his experience there, and I'm grateful we're debating them thoroughly today. I'll move now, if I may, to discuss Amendments 43 and 283 ZA, tabled by the noble Baroness Lady Fox of Buckley. Amendment 43 aims to ensure that the user empowerment content features do not capture legitimate debate and discussion, specifically relating to characteristics set out in subsections 11 and 12. Similarly, her Amendment 283 ZA aims to ensure that Category 1 services only apply the features to content when they have reasonable grounds to infer that it is user empowerment content. With regard to both of these amendments, I can reassure the noble lady that upholding users' rights to free expression is an integral principle of the bill and that it has been accounted for in the drafting of these duties. We've taken steps to ensure that legitimate online discussion or criticism will not be affected and that companies make an appropriate judgment on the nature of the content in question. We've done this by setting high thresholds for inclusion in the content categories and through further clarification in the bill's explanatory notes, which I know she has consulted as well. But the definition here deliberately sets a high threshold. By targeting only abuse and incitement to hatred, it will avoid capturing content which is merely challenging or robust discussion on controversial topics. Further clarity on definitions will be provided by Ofcom through regulatory guidance on which they'll be required to consult, and that will sit alongside Ofcom's Code of Practice, which will set out the steps companies can take to fulfil their duties.
I appreciate the comments made by the noble lord. It's quite straightforwardly that incitement to hatred and abuse are, as I've indicated or tried to indicate, despite people thinking that they know what they mean, are causing huge amounts of difficulty legally and in institutions throughout the land. So I think that Ofcom will have its work cut out, but it's entirely for that reason that I raised the amendment that it needs to be even higher a threshold and very carefully thought through.
But as the noble lady, I think understands from that reference, this is definition which is already in statute and with which Parliament and the courts are already engaged. The bill's overarching freedom of expression duties also apply to Clause 12. Subsections 4 to 7 of Clause 18 stipulate that Category 1 service providers are required to assess the impact on free expression from their safety policies, including the user empowerment features. This is in addition to the duties in subsection 2 of Clause 18, which requires all user-to-user services to have a particular regard to the importance of protecting freedom of expression when complying with their duties. Her amendment 283ZA would require Category 1 providers to make judgments on user empowerment content to a similar standard as is required for illegal content, and that would be disproportionate. Clause 170 already specifies how providers must make judgments about whether content is of a particular kind and therefore in scope of the user empowerment duties. This includes making this judgment based on all relevant information. As such, the bill already ensures that the user empowerment content features will be applied in a proportionate way, which will not undermine free speech or hinder legitimate debate online. Amendment 47, which has been tabled by the noble Lord Stevenson of Balmacara, would require the Secretary of State to lay a statement before Parliament outlining whether any of the user empowerment duties should be applied to children. I recognise the significant interest that noble lords have in applying the Clause 12 duties to children. The bill already places comprehensive requirements on Part 3 services which are likely to be accessed by children. This includes undertaking regular risk assessments of their service, protecting children from harmful content and activity, and putting in place age-appropriate protections. If there is a risk that children will encounter harm, such as self-harm content or unknown or unverified users contacting children, service providers will need to put in place age-appropriate safety measures. Applying the user empowerment duties for child users runs counter to the bill's child safety objectives and may weaken the protections for children, for instance by giving children an option to see content which is harmful to them or to engage with unknown, unverified users. So while we recognise the concerns in this area, for the reasons I've set out, the government does not agree with the need for this amendment. I will resist the noble Lord Knight's challenge to talk about bots, because I will look forward to doing so in the group where we talk about future proofing, but I look forward to returning to that then. And with that, I would invite noble lords.
May I just ask, I noticed the points made about the way that information is pushed, and in particular the speech of the Right Reverend Prelate. Nothing in the government's response has really dealt with that concern. And I just wonder whether you could say a few words about not the content, but the way in which users are enveloped. And in doing so, maybe I could take the idea that companies always act, they have a commercial imperative not to put users in a position of harmful material, because actually they have a commercial imperative to spread, engage users. And it's very, very well recorded that, in fact, a lot of that is the spread of harmful material. So I just wonder whether you could speak a little bit more about the features rather than the content.
It comes to the definition of content in the bill, which covers features. But I was struck by the speech of the Right Reverend Prelate about the difference between what people encounter online and the analogy used by the Noble Baroness Lady Fox about a bookshop. Social media is of a different scale and has different features which make that analogy not a clean or easy one. And we will debate in other groups the sort of accumulated threat of features such as algorithms. If the Noble Baroness will allow me to go into greater detail then, but I certainly do take the points made both by the Right Reverend Prelate and the Noble Baroness Lady Fox in the contributions they made.
My Lords, can I thank my noble friend very much indeed. In fact, can I thank all noble lords who have taken part. I think, as the noble Lord, Lord Knight said, this has been an important debate. They're all important, of course, but I think that this has really got to the heart of parts of this bill, parts of why this bill has been proposed in the first place, and some choices that the government has made in its drafting and the changes that it's made to this bill. As the Right Reverend Prelate said, as bishops always do, he reminded us of the bigger picture, and he was quite right to do that. There is no equality of arms, as he put it, between most of us as internet users and these enormous companies that are changing and have changed our society. And I think that my noble friend was completely right just at the end. I was going to pick up on it too. The bookshop example given by the noble Lady Fox is, I'm afraid, totally misguided. Because the point about a bookshop is that I love bookshops. I can choose to walk into it or not. If I don't walk into a bookshop, what I don't see are the books spilling out and the books promoting some of the content that we've been discussing today, spilling out onto the street, so I have to trip over them and can't ignore them. Even harder if I were a vulnerable person, as we are going to discuss. Noble Lords have said that this is not a debate about content. Today, it's not a debate necessarily about freedom of expression, it's about features, and I think that is right, but it is a debate about choice, as the Noble Lord Clement Jones said. And I'm very grateful to each of those noble lords who supported my amendments, and I think we've had a good debate on both sets of amendments that are similar. But as the noble Lord Griffith said, he said some of the content we are discussing, particularly in subclause 10 relating to suicide, pro-self-harm, pro-anorexia content, has literal life or death repercussions. So those noble lords and those outside this house who seem to think that this bill sometimes, and we shouldn't worry, we should allow total free-for-all, we are in that, and the government, in choosing not to adopt such amendments, is making an active choice, and I'm afraid the government is condoning the serving up of insidious, deliberately harmful, and deliberately dangerous content to our society, to younger people and to vulnerable adults. And I would just say to the Minister that actually he would be better off if he just, and the government said, that is the choice that we have made. I find it a really troubling choice because, as many noble lords will know, I was involved in this bill. a number of years ago. There's been a certain turnover of culture secretaries in the last couple of years, and I was one of them. And I find that choice really, really troubling. But it is a choice that has been made, and we're better off just to say that is the choice we've made. And as the Noble Lord Knight said, we are treating children differently than we are treating adults. And as drafted, there is a cliff edge at the age of 18. And I think that as a society, we should say that there are vulnerabilities amongst adults, as we do in many walks of life, and there are times when actually, exactly as the noble Lady Baroness Parliament so powerfully said, there are times when we as a house, as a parliament, as a society, as a state, should say we want to protect people. And there is an offer here in these amendments, both sets of amendments, and I'm not particularly precious about which ones necessarily we choose, to have that protection. So, I will, of course, withdraw these amendments today, because that's the convention of this House. But I would ask my noble friend to reflect, and I think the whip on the bench will report as well, on the strength of feeling that this House has expressed on this today. Because we will return to this, I am absolutely certain, probably with a unified set of amendments, at report stage, and the government will have to explain, I think in words of one syllable, to those outside this House who worry about the vulnerable that they are working with or looking after, about the choice that the government has made in not offering protections when it could have done in relation to these enormously powerful platforms and the insidious content they serve up repeatedly in the algorithmic debate that we will return to.
Is it your Lordship's pleasure this amendment be withdrawn? The amendment is by leave withdrawn. Amendment 35, Baroness Morgan, not moved. Not moved. Amendments 36 and 37, Lord Clement Jones, not moved. My Lords, we come now to Amendment 38. I should advise the House, the committee, that if this amendment is agreed to, I shall not be able to call Amendment 38A by reason of preemption. Amendment 38, Lord Moylan.
My Lords, I'm going to endeavour to be relatively brief. I rise to move Amendment 38 and speak to Amendments 39, 139 and 140 in this group in my name, all of which are supported by my noble friend Lord Vesey of Didcot, to whom I'm grateful. 38 and 39 relate to Clause 12. They remove subsections 6 and 7 from the bill. That is, the duty to filter out non-verified users. Noble Lords will understand that this is different from the debate we've just had, which was about content. This is about users and verification of the users rather than the harm or otherwise of the content. I'm sure I didn't need to say that, but perhaps it just helps clarify my own thinking to do so. Amendments 139 and 140 are essentially consequential, but they make clear that my amendments do not prohibit Category 1 services from offering this facility. They make it a choice, not a duty. I want to make only really one point in relation to these amendments, and that is that it has been well said elsewhere that this is a Twitter-shaped bill, but it is trying to apply itself to a much broader part of the internet than Twitter or things like it. In particular, community-led services like Wikipedia, which I've made reference to before, operate on a totally different basis. What the bill seeks to do is to create a facility whereby members of the public like you and me can say that we want the provider to, first of all, to verify, to offer a facility for verifying those who might use their service, and secondly, for us to be able, as members of the public, to say we only want to see material from those verified accounts. But of course, the contributors to Wikipedia, first of all, are not verified because Wikipedia has no system for verifying its users. And therefore, it would be impossible for Wikipedia as a Category 1 service to be able to comply with this condition on its current model, which is, as noble lords know from previous comments, of course, a non-commercial model. It is not intended to be, it is a non-profit. But it would not be able to operate this clause. It would either have to say that it is going to require that every contributing editor, everyone who makes a contribution to Wikipedia, would have to be verified first in order to do so, which would be extremely onerous, or they would have to make it optional, which would be difficult, but would lead to the bizarre conclusion that you could open an article on Wikipedia and find that some of the sentences in it, or some of the words, were blocked, and that you couldn't read them because they had been contributed, those amendments to the article had been made by somebody who hadn't been verified. And of course, putting a system in place that would allow that absurd outcome would itself be an impossible burden on Wikipedia. So my complaint, as always, in a sense, about this bill is that it misfires. Every time you sort of touch it, it misfires in some way or other, because it hasn't properly been thought through. It's trying, perhaps, to do too much across too broad a front, when in fact it's clear that the concern of the House is much narrower than trying to sort of bowdlerize Wikipedia articles, which really is not the objective of anybody here, but is what the bill is tending to do. Now, I'll conclude by saying, and I invite my noble friend to comment on this if he wishes. I think he's going to have to comment on it at some stage. That in reply to an earlier debate in committee, I heard him say somewhat tentatively that he did not think Wikipedia would qualify as a Category 1 service. Now, I think I'm not an advocate for Wikipedia, I'm just a user. But I think we do need to know what his view and the government's view is on that question. Wikipedia and services like it. Wikipedia is the only community-led service, I think, of such a scale that it would potentially qualify as Category 1 because of its size and reach. But if his view is that Wikipedia would not qualify as a Category 1 service, in which case my amendments are irrelevant because they wouldn't be caught by this clause, then I think he needs to say so. But more than that, I think he needs to say on what basis it wouldn't qualify as a Category 1 service. That is, would it be on the face of the bill? If it's not on the face of the bill, would it be in the directions given by the Secretary of State to the regulator? Or would it be a question of the regulator deciding whether it was a Category 1 service? Because obviously, if you're trying to run some sort of operation like Wikipedia with a future, you need to know which of those things is. Do you have security, legal security, against being determined as a Category 1 provider? Or is it something that is merely at the whim of a regulator? Whim is not the right word, but at the decision of the regulator in circumstances that may change or may legitimately change, and the regulator may have good or bad reason for changing that determination later. You can't run a business not knowing these things. So I put it to noble lords that this clause needs very careful thinking through. If it is to apply to community-led services such as Wikipedia, then it is an absurdity. If it is not to apply to them because what I think I heard my noble friend say pertains, and they are not, in his view, a Category 1 service, then why are they not a Category 1 service, and on what security do they have in knowing that either way?
My Lords, I rise to speak to Amendment 106.
And I beg to move.
The question is Amendment 38 proposed, page 12, line 24, leave out subsection 6.
My Lords, I rise to speak to Amendment 106 in my name and that of my noble and learned friend Lord Garnier and the noble Lord Moore of Etchingham. This is one of 5 amendments focused upon the need to address the issue of activist-motivated online bullying and harassment,
and thereby better safeguard the mental health and general well-being of potential victims. Schedule 4, which defines Ofcom's objectives and setting out codes of practice for regulated user-to-user services, should, we believe, be extended to require the regulator to consider the protection of individuals from communications offences committed by anonymous users. The government clearly recognises that there is a threat of abuse from anonymous accounts and has taken steps in the bill to address them. But we are concerned that its approach is insufficient and may be counterproductive. Let me explain. Its approach is to require large social media platforms to make provision for users to have their identity verified and to have the option of turning off the ability to see content shared by accounts whose owners have not done this. However, all this would mean is that people cannot see the abuse being levelled at them. It would not stop the abuse from happening, and crucially, it would not stop other people from seeing it, or the damage to his or her reputation or business, and the victim may suffer as a result. If I'm a victim of online bullying and harassment, it's true that I don't want to see it, but I don't want it to be happening at all. The only means I have of stopping it is to report it to the platform and then hope that it takes the right action. Worse still, if I've turned off the ability to see content posted by unverified, i.e. anonymous accounts, I won't be able to complain to the platform as I won't have seen it. It's only when my business goes bust or I am shunned in the street that I realise that something is wrong. The approach of this bill seems to be that if it is the innocent victim who may, for example, breed livestock for consumption, then it's up to the breeder to be proactive to correct harm already done by someone who doesn't approve of eating meat. This is making a nonsense of the law. This is not how we make laws in this country, until now it seems. Practically speaking, the worst that is likely to happen is that the platform might ban their account. But if their victims have had no opportunity to read the abuse or report it, even that fairly low impact sanction could not be levelled against them. In short, the bill's current approach, I'm sorry to say, would increase the sense of impunity, not lessen it. One could argue that if a potential abuser believes that their victim will not read their abuse, they won't bother issuing it. But unfortunately, this misunderstands the psyche of the online troll. Many of them are content to howl into the void, satisfied that other people who have not turned on the option to filter out content from unverified accounts will still be able to read it, and the troll's objective of harming the victim may be partially fulfilled as a result. There is also the question of how much uptake there will be of the option to verify one's identity, and numerous questions about the factors that this will depend upon. Will it be attractive? Will there be a cost? How quick and efficient will the process be? Will platforms have the capacity to implement it at scale? Will it have to be done separately for every platform? If uptake of verification is low, most people simply won't use the option to filter content of unverified accounts, even if it did mean they remained more susceptible to abuse, since by doing so they would be cutting themselves off from most of their users. Clearly, that is not an option for anyone using social media for any promotional purpose, and even those who use it for purely social reasons will find that they have friends who don't want to be verified. Fundamentally, people use social media because other people use it. Carving oneself off from most of them defeats the purpose of the exercise. It's not at all clear what specific measures this bill could take to address the issue. Conceivably, it could simply ban online platforms for maintaining user accounts whose owners have not had their identities verified, but this would be truly draconian and most likely lead to major platforms exiting the UK market, as Baroness Fox has rightly argued in respect of other possible measures. It would also be unenforceable, since users could simply turn on a VPN, pretend to be from some other country where the rules do not apply, and register an account as though they were actually there in that country. However, there are numerous underlying issues that this bill recognises as problems but does not attempt to prescribe solutions. Its general approach is to delegate responsibility to Ofcom to frame its codes of practice for operators to follow in order to effectively tackle these problems. Specifically, it sets out lists of objectives that Ofcom, in drawing up its codes of practice, will be expected to meet. The protection of users from abuse, specifically by unverified or anonymous users, would seem to be an ideal candidate for inclusion in this list of amendments, because if required to do so, Ofcom could study the issue closely and develop more effective solutions over time. My Lords, I was pleased to see an article in last week's Telegraph which gave an all too common example of where the livelihood of a chef running a pub in Cornwall has suffered what amounts to vicious abuse online from a vegan who obviously doesn't approve of the menu and is damaging the reputation of the business and putting the chef's livelihood at risk. This is just one tiny example, if I can put it that way, of the many thousands that are happening all the time. 584 readers left comments, and just about everyone wrote in support of the need to do something to support that particular chef and tackle this vicious abuse. I return to the point that I made in a previous debate. It's livelihoods at stake here that we're deeply concerned about. I'm not talking about big business. I'm talking about individuals, small businesses, family businesses that are suffering beyond abuse. They're suffering loss of livelihood, financial harm and or reputational damage to business, and the knock-on effects of that.
I beg to move that the debate on Amendment 38 be adjourned.
The question is that the House be resumed. As many as have the opinion... Amendment 38. The debate on Amendment 38 be adjourned. As many of their opinion was they content? The country not content? The contents have it.
My Lords, I beg to move that the House be resumed in committee stage of the Online Safety Bill to recommence not before 1941.
Do I stick to my script now? The question is that the House be resumed. As many as are of that opinion will say content. The country not content. The contents have it.